Friends, good afternoon from Goa. I was spending my time and thought of sharing one of the topic that is discharge of accused in criminal cases. So let us proceed on this topic. If we go by our criminal procedure code, the accused can file discharge application if he has been maliciously charged. If the allegation which have been made against him are false, then CRPC 1973 provides the provisions for filing of discharge application. So, if the evidence given before the court is not sufficient to satisfy the offence, and in the absence of any prima facie case against him, he is entitled to discharge. So, there are provisions where he can file his discharge application. Before proceeding further on this topic, let us go through types of criminal cases. Two major classification of criminal cases under the CRPC are: first one is cases instituted on the basis of police report, and second one is cases instituted otherwise than on police report based on the complaint. As far as cases instituted on the basis of police report, you can go through sections 230A to 243. And in complaint cases, you can go through section 244 to 247. For these two major classifications, there are further procedures provided in the CRPC. So that procedure can be divided into four types. It can be summary trial. It can be summoned case, that is by magistrate, or third one can be warrant cases by the magistrate, and fourth can be trial before the court of session. As far as summary trials are concerned, you can go through section 260 to 265. And for summons cases, you can go through section 251 to 259 of CRPC. For warrant cases by magistrate, you please go through section 238 to 250. As far as trial for session is concerned, you can consult section 225 to 237. So, the procedure of brunt cases is used for trial of brunt cases by magistrate and trial before the session. Brunt cases and session, case trial before the session, that is procedure of brunt cases is adopted. And as far as trial of summon cases by the magistrate and summary trial, then procedure of summons case trial is used. Now coming to the main topic, discharge of the accused in brunt cases. Naturally, when it is brunt case, on the basis of police report. What the procedure says that the police, after completing its investigation, files the charge sheet, you can say final report, under section 173 of CRPC. Thereafter, trial against the accused commences by the concerned court. However, there is provision of section 239 and 227 of the CRPC, which provides that before the charges are framed against the accused person, he can be discharged, depending upon the material. Now, coming to our mentioned section 239 of the CRPC, which states that when accused shall be discharged. I am going by the wording of section. If upon due consideration of police report and all the documents sent under section 173 along with examination of the accused, if any, as magistrate thinks obligatory and after hearing prosecution as well as accused, the magistrate considers the charge to be groundless against the accused, he shall, word is used, shall, he shall discharge the accused and also record the reason for doing so. So, as per above statement, what the essential elements of our discharge are, firstly, the court have to consider the charge sheet and documents appended thereto by the police under section 173 CRPC. Secondly, the magistrate may, if he deems fit, examine the accused and arguments of both the prosecution and accused should be heard. There should not be any evidence present against the accused. If the court considers that there is no prima facie case against the accused, if all the above mentioned conditions are fulfilled, then the accused shall be discharged. So the question in your mind must be going on whether the magistrate has to take cognizance of the material brought by the accused when the charge sheet is before the court, final court. And if the accused wants to say something at the stage, can the magistrate take cognizance of the material that is brought by the accused? For this case, we have to go by the ratio of Satish Mehra versus Delhi administration and another reported in 1996, volume 9, SCC 766. In the judgment, our Honorable Apex Court held that under section 239 of CRPC, the magistrate has to give the prosecution and the accused a chance of being heard, besides taking cognizance of the police report and documents sent there. The magistrate should apply judicial mind while considering the discharge application. Well, he should not mechanically order the discharge, but has to apply his judicial mind. And if the accused produces any trustworthy material at the stage, which can drastically affect even the very feasibility of the case, it would be very inappropriate to recommend that no such material shall be taken into consideration by the court at that stage. So the court can take cognizance of that trustworthy material by the accused at that stage for discharge purpose. Now coming to session trial, when the accused shall be discharged. So we have to go through section 227 for that. What the section 227 of the code defines is, if the court judge considers that there is no sufficient ground for proceeding against the accused upon hearing the submissions of the prosecution and accused and consideration of the record of the case along with the documents submitted therewith, he shall discharge the accused and record reasons also for doing so. So, as per above ingredients of section 227, where the session judge is bound to discharge. So, what are the mandatory ingredients where the session judge has to discharge the accused? First one is if there is prior judgment of the High Court, where the prosecution is clearly barred by limitation. We all know that there in our CRPC, there is time limit to put the legislative motion as per the punishment defined by the Act. If the acts are below 3 years, then they will become time barred after spans of 3 years. If it is up 3 years or more, then it can be at any time brought before the machinery, judicial machinery, or the kind of criminal procedure that the case will run on from that knowledge, that information. And when the evidence produced is not sufficient, then he is bound to discharge. Where there is no legal ground for proceeding as the accused, or where no sanction has been obtained. So these are the mandatory situations where the session judge is duty bound to discharge, and it is mandatory also. So, going by the procedure of discharge under section 227 of the CRPC, we have to read section 227 CRPC with section 226 CRPC. If both are read together, then we can go to some conclusion in how to discharge the accused. Now, if we go by the definition of section 227 CRPC, there are two important words. Hearing submission of the accused, second by no sufficient ground for proceeding against the accused. These are two mandatory situations which must be there to discharge him under section 227. After receipt of case documents supplied under section 207 CRPC, can the accused bring it to the notice of court that no material is available to proceed the case against him, and can he ask for discharge? I have already explained that discharge is a judicial order. He can apply judicial might. Now, what should be the guiding principle on discharge and framing of charge? There are few of the judgments of the Honorable Supreme Court through which we can formulate guiding principle. First one is Vijayan versus State of Kerala. Second is Union of India versus Prafulla Kumar, Samal and Kanal. So, forwarding toward these 7 guiding principles, the judge, while considering the question of framing the charge under section 227 CRPC, has the undoubted power to shift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. To determine prima facie case will depend upon the facts of each case. Second principle is where the materials placed before the court disclose grave suspicion against the accused, which has not been properly explained, the court will be fully justified in framing a charge and proceeding with the trial. Third principle is the court cannot act merely as a post office or a mouthpiece of the prosecutor, but it has to consider the broad probabilities of the case. There cannot be a roving inquiry into the pros and cons of the matter and weigh the evidence as if a trial was being conducted. Fourth principle is on the basis of material on record, if the court could form an opinion that accused might have committed the offense, it can frame the charge. Fifth principle is at the time of framing the charges, the probative value of the material on record cannot be gone into. But before framing of the charge, the court must apply its judicial mind on the material placed on record and must be satisfied that commission by the accused was possible. On the mere probability of possibility, charges can be framed. So, going to sixth principle from the above judgments, if at the stage of section 227 and 228 CRPC, the court is required to evaluate the material and documents on record with a view to find out the existence of all the ingredients constituting the alleged offense. But the court cannot be expected to presume that prosecution story is gospel truth. And seventh principle is if two views are possible and one of them gives rise to suspicion only, as distinguished from grave suspicion, the trial judge will be empowered to discharge the accused irrespective of the result of trial. I mean to say, the suspicion should be grave suspicion. If it is just a suspicion only, then there are chances of discharge of the accused. And secondly, the jurisdiction of the session judge at the time of the charge is very limited. Charge can also be framed on the basis of strong suspicion. Marshalling and appreciation of evidence is not in the domain of the court at that point framing charge. Now, if we go through the ratio of landmark judgments of 2010, volume 9, SEC 368, that is Sajjan Kumar versus CBI. In it, it was held that at the stage of framing of charge under section 228 CRPC or while considering the discharge petition under section 227 CRPC, it is not for the judge concerned to analyze all the material, including pros and cons, reliability or acceptability, the evidentiary value and its credibility and veracity has to be considered at the stage of trial. Now, going by another case, that is state of Tamil Nadu, represented by Inspector of Police Vigilance and Anti-Corruption versus N. Shresh Rajan, also known as ACB case. It says that at the stage of consideration of an application for discharge, court has to proceed with an assumption that the material brought on record by the prosecution are pure and to evaluate the said material and documents with a view to find out whether the facts emerging therefrom taken at their face value disclose the existence of all the ingredients constituting the offense. Now, again, the question arises, can the material which is produced by the accused be looked into by the session court? Already discussed Satish Mehra versus Daily Administration, 1996, Volume 9, SEC 766. Our Honorable Supreme Court held that if the accused produces any convincing material at the stage of framing of charge, which might drastically affect the very sustainability of the case, it is unfair to suggest that no such material should be considered into by the court at that stage. Now, question comes whether the discharge can be post framing of the charge. We have one case law that is Rati Lal Bhanji Mathani versus State of Maharashtra, AIR 1979, Supreme Court 94. In this case, it was held that after framing of charge, the question of discharge does not arise. The same view I taken in the case of Shri Atyachar Virodhi Parishad versus Dilip Nathumal Chordia, 1989, SEC 1715. And further, in the case of Tapati Bag versus Pati Pavan Ghosh, that was reported in 1993, CRLJ 3932, Calcutta, in which it was held that if the court considers that there are no sufficient grounds for proceeding against the accused has to be discharged. But if the court is of the opinion, after such consideration, that there is ground for presuming that the accused has committed the offence, which is exclusively triable by the Court of Session, then the charge against the accused must be framed. Once the charges are framed, the accused is put to trial, and therefore either there will be acquittal or conviction, but he cannot be discharged. Once charges are framed under Section 228 of the Code, there is no barrier for the discharge of the accused under Section 227 of the Discharge post framing of charges not viewed in CRPC. So there is no provision if the post framing charge no discharge. Now, taking the situation of the discharge of accused in cases which are trialable exclusively by the Court of Session. In the case of Sanjay Gandhi versus Union of India, that was reported in AIR 1978 SC 514. In this case, it was held that there is no such permission that permits the magistrate to discharge the accused. Discharge order can be given only by the trial court, and in respect of offences exclusively triable by Court of Session, the Court of Judicial Magistrate is not the trial court, so he is having no power to discharge. Now, coming to another case, that is State versus Om Prakash, Delhi High Court. In this case, Honorable Justice Suresh Kumar Kat, the case was decided on 6th November 2019. It was held that the discharge of the accused under Section 12 of the POCSO Act, where victim did not mention any act of sexual assault, or intent in her 164 CRPC statement. FIR was being registered on the statement made by the mother of the victim. Then the discharge can be. Now, there is another case, that is Shiroj Singh Alawat versus State of UP, that is of 2013, volume 11, SCC 476. At the time of framing of the charge, the court is required to evaluate the material and documents on record to decide whether there is a ground for presuming that the accused had committed the offence. There is no need to evaluate the sufficiency of evidence to convict the accused. Materials brought on record by the prosecution can be believed to be true, but their probable value cannot be decided at that stage. The accused is entitled to urge his contentions while entertaining the discharge application only on the material submitted by the prosecution, but he is not entitled to produce any material at that stage, and the court is not required to consider any such material. If two views are possible and one of them gives rise to suspicion, only as distinguished from grave suspicion, the trial judge is empowered to discharge the accused, irrespective of the result of the trial. Now, coming further case, R.S. Mishra versus State of Odisha, AIR 2011 SC 1103. Has victim right to be heard during discharge? It says, this judgment says that normally a victim is not participating in discharge proceeding under section 227 CRPC. If in a case wherein the victim is not sufficiently reported by the prosecution, and in cases where the interest of the victim adequately protected, there is nothing wrong on the part of the victim in stepping in with a request for being heard. In such cases, the version of the victim should not remain unheard. Coming to further case, that is State of Karnataka Lokayukta M.R. Hiramat of 2019 SCC, and the contents has been taken from page 734. At the stage of considering the application for discharge, the court must proceed on the assumption that the material which has been brought on record by the prosecution is true, and evaluate the material in order to determine whether the facts emerging from the material taken on its face value disclose the ingredients of necessary to constitute the offence. And in the case of State of Karnataka versus L. Muniswamy, AIR 1977, SC, page 1489. Our Honorable Supreme Court held that the object of the provision which require the session judge to record its reason while entertaining discharge petition under section 227 CRPC is to enable the superior court to examine illegality of the impugned order. In that case, the trial court did not assign any reason in the impugned order while refusing to discharge the accused. As such, it suffers serious infirmity. Now, one more case, that is State of Odisha, versus Devendranath Padi 2005 1 SCC, and the page is 568 AIR 205 SC, page 369. In this case, the three-judge bench of the Honorable Supreme Court held that Section 227 CRPC is enacted in the code for the purpose of saving the accused from unnecessary harassment by feeling prolonged trial. The same principle was laid down in Kevan Krishna versus Surajbhan 1980 SCC Supplement P 499. The Honorable Apex Court observed in this case that decision rendered by it in the case of Satish Mehra versus Delhi administration is not a good law. Now coming to discharge applications in cases instituted on the basis of police report and otherwise. Section 239 of CRP. Before considering the application for discharge under Section 239 CRPC, what aspects are to be considered for discharge? Let us go through this. Now, when the police files the final report under Section 173 CRPC, it means that charge sheet containing certain allegations, which if proved constitute a punishable offence. Even in a private complaint filed under Section 200 CRPC, also the accused got such a right to seek discharge. However, there is major distinction as regard to discharge of an accused from a brunt case instituted upon a police report and a brunt case instituted upon a private complaint filed under Section 200 CRPC. Coming to first part, in a brunt case instituted upon police complaint, the magistrate has to consider the final report, statement of witnesses recorded under Section 161 CRPC, documents. If he feels necessary, he can examine the accused also. And if he finds that charges, allegations are groundless, he can discharge the accused under Section 239 CRPC or frame charges under Section 240 CRPC. But in a case instituted upon a private complaint, the procedure for charge or discharge is completely different from police case. Let us closely read Section 245. And if we go by the reading of Section 245 supply to CRPC, it would show that in a brunt case instituted upon a private complaint, after recording evidence, the discharge petition can be entertained. This is the major difference in private complaint. In a police case, there will be only one cross-examination. However, in a private complaint, there will be two cross-examinations. In a police case, trial commences on issuing copies under Section 207 CRPC, and on hearing the accused will be examined under Section 227 and 239 CRPC. But in a private complaint, trial will commence only after framing charges under Section 246 CRPC. That will be only after recording evidence under section 244 CRP. While recording preliminary evidence under section 244 CRPC, the accused can cross-examine the witnesses then and there, or he may defer the cross to be done after framing of the charges. After framing of charges, again the accused can cross-examine the witness. It is pertinent to note that at that stage, the quantum of evidence adduced is not the choice of the accused, but it is the choice of the complainant, which would be sufficient to frame charges in the opinion of the complainant. Now, let us discuss discharge in Brunt case. Section 239 CRPC is the provision under which the magistrate can discharge the accused in a Brunt case. The police report and documents filed under section 173 CRPC. Second, opportunity must be given to both prosecution and accused. The court has to hear them. Magistrate must feel the allegations are grounded. These are the parameters on which discharge is possible. Now the question is whether the court has to consider documents and evidence placed by the accused at the time of discharge. The Honorable Supreme Court in below mentioned three decisions, that is Satish Mehra versus Delhi Administration, State of Odisha versus Devendranath Parthi, Rajiv Thapar, and others versus Madanlal Kapoor. The magistrate has to give an opportunity of being heard before considering the police report and documents. Now, the question is whether the region order is necessary at the time of framing of charges. The answer is yes, region order is necessary. Now, let us evaluate or go through the discussion difference between discharge under section 227 CRPC and section 239 CRPC. Firstly, 227 CRPC. If the court considers that there is no sufficient ground for proceeding against the accused, and section 239 CRPC, if the magistrate considers that charges are groundless in both cases, the accused can be discharged under section 227 and 239 CRPC. Now, there is one case of Meenakshi Walla versus Sudhir Kumar, 1994, SCC 414. The magistrate is required to consider the police report and the documents submitted under section 173 CRPC, and he should take decision regarding discharge after hearing both parties. He had to discharge the accused under section 239 CRPC if the charge is groundless. The main ingredient is groundless charge. So, one charge is framed under section 240 CRPC. If the accused aggrieved, he should invoke the revisional jurisdiction of High Court or Session Court, claiming that the charge sheet under section 173 CRPC and documents does not disclose any ground to presume that he has committed any offense for which he was charged. When the material brought on report shows that the accused attempted to cheat the public, in such case, when there is a ground to presume that the accused committed the offense, then the discharge is not possible. If that is done, then the discharge is improper. And it is further to be noted that at the stage of framing charges, the prosecution evidence will not be commenced. The magistrate had therefore to consider the material placed before him by the IO. At this stage, the truth, veracity, and effect of evidence which prosecutor proposes to adduce are not to be meticulously judged. The finding with regard to guilt of the accused cannot be exactly to be applied, nor any presumption could be drawn. The only thing is to be taken into consideration regarding the existence of factual ingredients constituting the offense as alleged. Now, if the magistrate considers that there are grounds to discharge the accused, he must record the reason for doing so and get him discharged. The Honorable Supreme Court, in the case of Shri Mati Rumidar versus State of West Bengal, held that the magistrate, while entertaining the discharge petition under Section 239 CRPC, he has to go into the details of allegations made against each accused in order to form an opinion as to whether any prima facie case is made out or not, as well as strong suspicion in regard to subserve the requirement of law. And in another case of Om Karnath Mishra versus State of New Delhi, NC Delhi, the Honorable Supreme Court held that the court is not expected to go deep of the probative value of the material on record. What needs to be considered is whether a ground for presuming that the alleged offense has been committed, the existence of factual ingredients constituting the offense to frame the charge. Same view was taken in the case of Saroj Singh Ahlawat versus State of UP and another. And in Dr. J. Muralidhar versus State of AP, the petition under Section 239 CRPC was dismissed by the Special Court. Honorable High Court dismissed the revision on the ground that the discharge application has been correctly dismissed as voluminous material was collected by the investigating agency directly pointing out the complicity of accused for the alleged offense. So, in another case, that is of State of Himachal Pradesh versus Krishan Lal Pradhan, it is a case where the accused was discharged from the offences under Section 379, that is of theft case 411, 420, 218, 468, 120B, IPC read with Section 5 subclass 2D of the Prevention of Corruption Act by the Special Judge Civil. Firstly, the concerned judge implemented A7 to A10 on merits at the request of the state representing public prosecutor by observing that the material on record, that is charge sheet and 161 CRP statements of witness, reveal the existence of sufficient material on record against the accused, as well as implemented accused. Subsequently, there was a change in the presiding officer who discharged the accused on the ground that there is no sufficient material on record to connect the accused with the alleged offense. The said observation is dramatically opposite to the conclusion made by his predecessor and contrary to the consents of the charge sheet and section 161 CRPC statement. Later on, the Honorable High Court of Himachal Pradesh passed cryptic order as heard and dismissed without assigning any reason in the revision. The Honorable Supreme Court came heavily upon the trial judge for discharging the accused with erroneous perception, as the impugned order was based on mere surmises and conjectures. The trial judge passes the discharge order without proper scrutiny of the material, which connecting the alleged offences and failed to observe the concept of prima facie case. The SLP was allowed, directing the trial judge to frame the necessary charges. Consequently, the discharge order was set aside. Now, coming to section 245 of CRPC that deals with discharge of accused in brunt cases, instituted complete. Section 245 of CRPC talks about the situation when accused shall be discharged. Under section 245 subclause 1 CRPC, the magistrate should consider the evidence adduced under section 244 CRPC. And if we see that no case has been made out against the accused, if unreverted, it would not grant a conviction. Then he will discharge the accused from the case under section 245 subclause 1 CRPC. Otherwise, the magistrate has been left with no option to frame charge under section 246 subclause 1 of the CRPC. And under section 245 subclause 2 CRPC, at any previous stage of the case, if charge is groundless, he can discharge the accused. So also at any previous stage of the case, if there is a ground for presuming that the accused has committed an offence, the magistrate has to frame the charge. Now, let us have legal authorities for the work. In Union of India versus Prafulla Kumar, our Honorable Supreme Court held that the word used in the context not sufficient ground for proceeding against the accused, so that the judge cannot be assumed to be a post office to frame the charges at the instruction of the prosecution. And application of judicial mind to the facts of the case is necessary to determine whether a case has been made out by the prosecution for trial. In determining this fact, it is not mandatory to dive into the pros and cons of the matter by the court. So, friend, this is all about discharge applications. And the video is going to be too lengthy. So, I am keeping rest to my words, and I am thankful to the our respected writer of from where I have taken the contents, that is paper presentation by our respected Srimati Prema Rajeshwari, Special Session Judge, Nagar. I am lot of thankful to her for writing such a paper, and I am thanking her as I have taken some material from her presentation. So God bless you all. I feel you have enjoyed a lot. If there is any mistake from my side, please bear with me. Thank you for that.